Hello, I am Surya Subedi. I am Professor of International Law and the author of the study guide on international investment law. Today, I would like to talk about very briefly what is in section A. Like any other courses that you are undertaking, international investment law has 4 sections: section A, section B, section C and section D. Each of these sections deal with the different components of international investment law, and section A, which is the focus of my introduction today, deals with the evolution of international investment law and the basic principles of international investment law. How international investment law has come into existence is a long, one of the oldest areas of public international law is international investment law. Individuals and business organizations started to cross the borders, go to other countries with a view to investing in infrastructure related projects, in natural resource development projects, acquiring land, building hospitals, roads, dams, so on and so forth. All sorts of economic activities were taking place on the money invested by foreign investors in so many countries around the globe for so long. When companies or individuals go to other countries to invest their money, what protection they should get from the host government, from the host nation, that is the concern of international investment law. Foreign investors have come and committed their capital to that country. How do you encourage them to invest? How do you assure them that should something go wrong, their interest would be protected, or they will have a recourse to a legal mechanism to have a dispute resolved between the host country and the foreign investor. So, that is the reason we have the whole body of international investment law. As I said, since there is no comprehensive global convention on international investment law, much of the law is based on customary international law and the law flowing from bilateral investment treaties and regional investment treaties, and of course, the case law. Various international courts and tribunals have fleshed out the provisions of both customary international law and the principles embodied in the international bilateral or regional investment treaties. So, the evolution, the survey of the evolution of international investment law covers doctrines such as the Calvo doctrine, doctrines such as the Hull formula, how they came into about, what do they mean and how they have been applied and how relevant these doctrines or principles are today. That is the focus of this section A of the course. Then I go on to examine the main principles of international investment law. For instance, international minimum standard. Under customary international law, as you know, all foreign investors are entitled to the protection of international minimum standard. What do you mean by that one? Even in the absence of a bilateral investment treaty between the two countries concerned, a foreign investor should have the confidence and go in and invest in other countries, because they are entitled to the protection of provided by customary international law. The minimum protection under international law. What is the minimum protection? How do you define it? What are the core elements of it? What are the main principles of it? That is the focus of this section. Then the section goes on to examine the principles such as most favored nation treatment, under which conditions foreign investors are entitled to be treated or accorded the protection available under the principle of the most favored nation treatment, or under which conditions a foreign investor is entitled to have the protection of national treatment, or what do we mean, one of the main principles of foreign investment law is fair and equitable treatment. Every foreign investor has to be treated fairly and they should be accorded equitable protection. But what do we mean by that one? What do we mean by fair and equitable treatment? Books have been written, number of articles have been written. The concern for many of the international tribunals over a long period of time has been on the definition of the term fair and equitable treatment. So, what is the recent trend in law and jurisprudence? That is also the focus of this section. Then the section goes on to deal with various other principles of international investment law, flowing from both customary international law and bilateral investment treaties. Therefore, this section tells you how to do well in understanding the basic concepts of international investment law, the evolution of it, how it came into how it came into existence, and what are the basic principles today, and how these basic principles have found their way into the jurisprudence of international courts and tribunals. So, if you like, is an introduction to the entire course itself. Other sections go on to build on this section. This section lays down the groundwork for international investment law course in its entirety. Without having a proper understanding of section A, you will have difficulty in understanding the content of sections B, C and D. So, it is basically a general introduction to the course, general introduction to the world of international investment law and the current state of play in this area of law. Thank you.